Two Supreme Court justices just told you in writing exactly how they plan to dismantle your gun rights. And almost nobody's talking about it because it's buried inside a case called United States v. Hemani, a case gun owners are celebrating as a total win for the Second Amendment. Here's the headline everyone's running with. The Supreme Court just ruled 9-0, unanimous, protecting a man's gun rights. Gun groups are popping champagne. The NRA's happy, Cato's happy. It looks like a clean total victory for the Bruen standard. But while everyone is celebrating the Supreme Court's unanimous ruling, two justices just gave a terrifying warning about the future of your gun rights. Justices Ketanji Brown Jackson and Sonia Sotomayor didn't just vote with the majority. They used this exact case to lay out a legal roadmap for tearing apart that very test. Stick with me, because by the end of this, you're going to understand why a win for gun rights might be the most dangerous moment for gun rights in years. Let's be straight with each other for a second. This case isn't really about marijuana. It's about the rule book. Here's what happened. A man named Ali Hemani had his home searched by the FBI. They found a 9mm pistol, some weed, and a small amount of cocaine. He told agents he smoked marijuana every other day. Based on that alone, the federal government charged him under a law that bans unlawful users of controlled substances from owning a gun. A law that could have sent him to prison for 15 years. The Supreme Court said no, unanimously. The government can't strip away your Second Amendment rights just because you use marijuana occasionally, with no proof you're dangerous and no proof you're intoxicated when you use the gun. Now here's why you should care, even if you've never touched marijuana in your life. This case isn't really about drugs. It's about the test the courts use to judge every single gun law in this country. That test is the only thing standing between your rifle, your concealed carry permit, your home defense weapon, and the judge deciding your rights based on vibes instead of the Constitution. If that standard gets weakened, every red flag law, every magazine ban, every new sensitive places restriction gets a whole lot easier to justify. Your freedom to defend your home, your family, and yourself, that's what's actually on the table here. And two justices just told you, on the record, that they want it gone. So what exactly did they say? And why does it matter that they said it in a case they already won? Let's break down the story the headlines are telling you, and the part they're leaving out. If you scroll through the coverage, it's a feel-good story. Supreme Court delivers unanimous win for gun rights. 9 justices, 1 outcome, bipartisan unity on the highest court in the land. Case closed, everyone goes home happy. And look, to be fair, the legal argument Justice Jackson made in her concurrence isn't crazy. The most compelling argument for her position goes like this. Judges aren't historians. Forcing them to dig through centuries-old laws to find some relatively similar ancestor from the 1700s creates real, documented chaos in the lower courts, circuit courts reaching completely opposite conclusions on similar laws. One court upholding a gun ban for a guy convicted of failing to pay child support. Another striking down the same kind of law for a different nonviolent offense. She's not making that up. That inconsistency is real. And it's a legitimate problem worth taking seriously. However, and here's what they're not telling you, that critique wasn't necessary to decide this case. Nobody asked the court to revisit Bruen. Neither side argued for it. The government didn't ask. Hemani's lawyers didn't ask. Jackson and Sotomayor volunteered it anyway, in a concurring opinion, inside a 9-0 ruling that the media is selling you as total gun rights harmony. That's the gap. A clean, unanimous case is being used quietly as a launching pad for an argument nobody requested. And once something's written into a Supreme Court opinion, it doesn't disappear, it becomes permanent citation. So what does that roadmap actually say? And why pick this case of all cases to drop it? Let's get into the real mechanics here, because this is where it gets serious. First, the ruling itself. Justice Neil Gorsuch wrote the majority opinion. He said the government can't automatically strip someone of their Second Amendment rights just for occasional drug use, with no finding that that person is dangerous. According to the court's own opinions, the government's comparison to old habitual drunkard laws didn't hold up, because those laws targeted different people for different reasons in different ways than the modern statute does. Second, what Jackson and Sotomayor actually wrote. In her concurrence, joined by Sotomayor, Jackson stated plainly that the Bruen framework is unworkable and is vulnerable to inconsistent and arbitrary application, as judges draw different conclusions from the same historical evidence. That's not me paraphrasing for drama. That's the language in the official opinion. And she went further, proposing the court return to means-end scrutiny, which is the pre-Bruen approach that lets judges weigh your gun rights against whatever the government claims is a compelling interest. Now stop and think about what that actually means for a second. Means-end scrutiny sounds like dry legal jargon, but it's not. It means a judge gets to ask, does the government have a good enough reason to take this away from you? Not does history support it. Just, is the reason good enough? That's the whole ballgame. Third, why this matters more than the case itself, a Supreme Court concurrence becomes permanent legal record. It gets cited by lower court judges. It gets quoted by law professors, and it gets waved around in Senate confirmation hearings the next time a seat opens up. Jackson and Sotomayor just put their names on a document that says, the moment we get one more vote, this standard is gone. And here's the why now. A friendly, unanimous, pro-gun outcome case is the safest possible place to plant that flag. The headlines read as a win. Nobody's outraged about the result. It slides under the radar, except it didn't slide under ours. This isn't theoretical either. Right now, the court is sitting on Wolford v. Lopez, a case about Hawaii's law banning concealed carry on private property such as restaurants, stores, and gas stations, unless the owner explicitly says guns are welcome here. Gun rights groups call it the vampire rule. That decision is expected any time now. And there's a stack of other Second Amendment cases like magazine limits and age restrictions that the court has been sitting on, relisted again and again, seemingly waiting for Hemani and Wolford to land first. This framework is about to get tested, repeatedly in real time. So strip away the legal jargon. What does this actually mean if you care about limited government and individual liberty? Let's put it through that lens. Here's a principled version of why it matters. The historical tradition standard exists because it ties your rights to the actual text and history of the Constitution, not to a judge's personal opinion about what's reasonable. Means-end scrutiny, the approach Jackson wants back, lets the government claim a compelling interest and ask judges to balance that interest against your enumerated right. That's the administrative state's favorite trick. Take a hard constitutional line and turn it into a flexible "it depends," decided by unelected judges, case by case, mood by mood. Your Second Amendment right isn't supposed to be a privilege the government grants you when it feels like your reason is good enough. It's an individual, God-given right, written down, same as your right to speak freely. The moment courts get to balance it away for a government interest, your rights get smaller every single time someone in power decides they have a good enough reason. And this isn't a bash the Democrats moment either, because that's too easy and it's not the full picture. Look at who else showed up in this case. Justice Samuel Alito, a conservative, wrote his own separate opinion, joined by liberal Justice Elena Kagan. Even some legal scholars who lean conservative will admit Bruen has real application problems in the lower courts. The honest disagreement here isn't red versus blue. It's judicial discretion versus constitutional restraint. And that fight cuts across party lines whenever government power is on one side and your individual rights are on the other. Now look at Wolford. Hawaii's vampire rule flips property rights upside down too, assuming a business owner doesn't want a lawfully armed customer unless they say otherwise, out loud, every time. That's the government, not the property owner, setting the default. Same fight, different angle. State power deciding what your rights look like by default, instead of letting free people and free property owners decide for themselves. So where does all of this actually land? Let's talk about what happens if this trend keeps moving. I want to be careful here, because I'm not going to feed you some wild conspiracy theories. Let's use simple if-then logic. If courts go back to balancing your gun rights against government interests instead of measuring them against constitutional text and history, then the door swings back open to magazine bans, expanded sensitive place restrictions, and stricter permitting laws surviving legal challenges they'd currently lose. The domino effect is already lining up. The Wolford v. Lopez ruling on private property carry rights is expected any time now. That'll be the next real-world test of how far this standard actually holds. Behind that, there's a backlog of other Second Amendment cases the court has been sitting on, including challenges to magazine capacity limits and age-based purchase restrictions. Relisted conference after conference, like the justices are waiting to see how Hemani and Wolford shake out first. Timeline-wise, this is a two-speed threat. Short-term, over the next 6 to 12 months, Wolford's decision lands, and we find out fast whether this constitutional standard survives its next real test. Long-term, this is a slow burn. The real danger is the next Supreme Court vacancy. The moment that happens, this concurrence becomes Exhibit A in the confirmation fight, cited by name, used to vet the next nominee on exactly one question. Do you believe in Bruen or don't you? That's not paranoia. That's how the court works. Concurrences plant flags. Vacancies are when those flags get picked up. So here's the part that matters most. What do you actually do about it? Here's the good news. You're not powerless in this. Knowledge is the first weapon, and you've already got that. First thing, if this is the kind of story you want more of, hit subscribe right now. I track these rulings as they drop. In plain English, no legal degree required. Second, stay informed on Wolford v. Lopez specifically. When that ruling lands, it's going to tell us a lot about how durable your gun rights really are. Don't just read the headlines. Ask what the concurrences say, because that's where the next fight always starts. And third, if you live in a state actively expanding gun restrictions, your state legislators need to hear from you. State-level protections for the historical tradition standard exist, and they matter regardless of what happens in D.C. One more ask before we go. Subscribe and share this with one person who saw 9-0 in a headline this week and assumed this fight is over. They need to know it isn't, because a unanimous ruling didn't end this fight. It just showed you exactly who's planning the next one, and exactly how they intend to win it.